This is Colin O'Keefe for LXBN TV. Earlier this week, the Supreme Court handed down its first ruling on Sarbannes-Oxley whistleblower protections, and it's a decision that is getting a lot of attention. Joining me now to explain exactly what that ruling was and its impact is our resident whistleblower expert, Steve Pearlman. He is co-head of Proskauer's Whistleblowing and Retaliation Group and author on the firm's blog, Proskauer Whistleblower Defense. Steve, first, can you explain the ruling for us? What exactly happened?
Thank you, Colin. This is a landmark decision that has some sweeping implications. As you said, it's the first SOX case to ascend all the way up to the United States Supreme Court, so it's been watched very closely. The Supreme Court ruled in awfully eye-opening fashion that the whistleblower protection provision in Section 806 of Sarbanes-Oxley extends all the way out to cover contractors to publicly traded companies. That comes as a major surprise to the employer community because that means that scores of new employees have a cause of action under Sarbanes-Oxley. That means that many private companies are now covered. So, how did we get to this place? Well, the Supreme Court was awfully driven by what happened in Enron. The Supreme Court looked at the legislative history and said, not only did we have a concern with misconduct at Enron, but we also had a concern that folks who were accountants and other consultants to Enron were aware of certain improprieties at the company and stepped up, purportedly complained, and claimed to have been retaliated against and suffered retribution for identifying problems at Enron. And that's something that when you read between the lines in this decision, you see was of extreme importance to the majority in this 6-3 decision. Now, it's an awfully interesting response that you get from the dissent, and a very compelling one. Judge Sotomayor says, look, if you have the Supreme Court's interpretation of Section 806 as wide and broad as it is, then that means that nannies, that gardeners, that personal employees of officers of publicly traded companies are also going to have a cause of action. So my point is that this is a sweeping, super broad interpretation of SOX's coverage. Now, there's a couple of issues that caught employers' attention when this case came out. One, for example, was the extent to which the Supreme Court was going to give deference to the United States Department of Labor's interpretation of Section 806 of Sarbanes-Oxley. Curiously, the Supreme Court did not address that question. So many folks are wondering why, but if you look at footnote 11, it's apparent that the court didn't address that question. The second issue is this case is significant because of what it did not say. In this case, the Supreme Court said that contractors of publicly traded companies are covered. Well, what's a contractor? Let's say that a company sells a couple of widgets on one occasion to a publicly traded company. Does that all of a sudden make it a contractor with that one-time transaction? And let's say that there's a complaint that has absolutely nothing to do with the work that the contractor was performing for the publicly traded company. And that's what Judge Sotomayor was so concerned about. But the Supreme Court, quite frankly, considered those concerns to be fanciful and unrealistic.
I see, and you've already alluded to the impactful and far-reaching nature of this case, but speaking to that, can you elaborate a bit on just how big of an impact this has?
I think that we can realistically expect that in the near future, we will see a spike in claims by so-called whistleblowers at private companies. Now, this will come as a major surprise to private companies because since private companies have believed that they're not covered by and large by Section 806 of the Sarbanes-Oxley Act, they may not be in the top of the curve, to put it nicely, with respect to the state of their compliance programs. So they're going to have to pour resources into developing robust compliance programs. They're going to need to develop codes of conduct and anti-retaliation policies as well. And they're going to need to implement training of managers so that managers can spot issues that are apt to result in these types of claims, and so that managers can understand the implications of retaliating in any way, shape, or form against employees. So this is a sea change for many private employers who now need to step up and make sure that they're in compliance.
It's going to be very interesting to watch. As you mentioned, I would expect to see a major spike in claims in the relatively near future, and as a result of that, I would expect that you and I should be speaking relatively frequently in the not-too-distant future. Once again, that was Steve Pearlman of Proskauer. For more of his insight and commentary from his colleagues as well, be sure to visit whistleblowerdefense.com. That is whistleblower-defense.com. Thank you for joining me today, Steve.
Thanks so much, Colin.